Financing the aircraft, collateral perfection, and why records matter. Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Now, let's begin with the first truth in large turbine aircraft finance. The lender is never financing just an airplane. The lender is financing the aircraft, the engines, the records, the title chain, the operating plan, and the legal behavior of the people involved. In FAA terms, a large aircraft means an aircraft more than 12,500 pounds, maximum certified takeoff weight. For many business jets or other large turbine aircraft, the threshold is crossed immediately. That matters because large aircraft transactions trigger regulatory concepts that smaller aircraft owners often never confront with the same intensity. The legal spine begins with recordation. Under 14 U.S.C. Section 44107 and C.F.R. Part 49, the FAA maintains the federal recording system for conveyances, leases, and security instruments affecting aircraft and certain engines, propellers, and parts. The federal system is not a decorative filing cabinet. It is the place where title and lien priority become real. And the warning is simple. If you have not recorded properly, you may discover too late that you do not have the priority you thought you bought. The Supreme Court's decision in Philco Aviation versus Shackett remains and often the memorable example. The court made clear that the federal recording system preempts state law approaches that would allow undocumented or unrecorded transfers to defeat innocent third parties. In practical terms, a handshake may transfer possession. It does not safely transfer priority. There is a second point practitioners sometimes miss. FAA recording is important, but FAA recording is not title insurance from the government. Under 14 CFR Section 49.17, the recording of a conveyance is not a decision by the FAA that the instrument actually affects title or an interest in the aircraft. In other words, filing is essential, but filing alone does not cure bad drafting, missing authority, broken entity power, or a defective chain of ownership. That is why disciplined due diligence matters so much in large turbine deals. Before money moves, counsel and lenders should test at least 6 things. Who owns the aircraft now? Whether the seller can actually convey it, whether every prior release has been properly recorded, whether the engines and installed equipment are described correctly, whether the maintenance records support the represented status, and whether the proposed use of the aircraft will fit the financing structure. The maintenance point is especially important. Under 14 CFR Section 91.403, the owner or operator is primarily responsible for maintaining the aircraft in an airworthy condition. That matters not only for safety, but for collateral value. In large turbine aircraft, missing logbooks, unresolved airworthiness or AD history, questionable component traceability, or unclear inspection status can destroy financeability faster than a minor cosmetic defect ever could. AOPA Finance put the point in practical market terms in 2025 when it explained why lenders often insist on engine maintenance programs for jets. Much of the residual value in older turbine aircraft may sit in the engines, and a current transferable program reduces the lender's exposure if the aircraft is returned to the bank or lender. That is not merely a convenience issue, it is collateral discipline. There is also an international dimension. For Cape Town eligible airframe and engines, the FAA explains that the international registry is an additional filing located location for qualifying assets, including prospective interest. That means sophisticated finance or large turbine aircraft often require counsel to think in two systems at once: the domestic FAA recordation and international priority protection. Here's a memorable point. In large turbine aircraft finance, the metal flies, but the paperwork decides who gets paid. A simple example here helps. Suppose a borrower acquires a large cabin jet through a newly formed special purpose entity. The term sheet is signed. The bank wires funds and everyone celebrates the closing. But the bill of sale is inaccurate and the security agreement does not match the debtor name exactly. A prior release was never filed and the engine serial numbers are sloppy. In conversation, that still sounds like a closed deal. In litigation, it sounds like an invitation. So the first job in aircraft finance is not to admire the aircraft. It's to make the asset legally recognizable, technically supportable, and recordable without ambiguity. In short, large turbine aircraft financing starts with a basic discipline. Know what the collateral is, know how the priority is protected, and know whether the records tell the same story as the purchase price. Remember this and take this away. In aircraft finance, the jet is the headline, but the records are the collateral. Thank you for your interest in this topic. This information is provided for informational purposes only and should not be construed as legal advice. Questions are certainly welcome. Please direct them to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues as well as answer your questions with precision.